Hello, I'm Rachel Arndt,
And I'm Andy Perkins.
and we are attorneys at Peterson, Wagoner, and Perkins in Rochester, and today we'll be discussing public records and information.
Public information comes to us from two sources, from private sources and government sources.
Government information comes from three sources. The first source is from state agencies like the Bureau of Motor Vehicles or the Department of Natural Resources. The second source are from political subdivisions. Those are towns, sometimes those are government entities. And then the third source of government information are the courts.
First law that impacts state and local government is the Open Door Law. The Open Door Law essentially requires that meetings be open to the public, with some exceptions. County commissioners, the Indiana State Board of Education, the City Council, all of these entities have to have public meetings, and that's the general rule. The rule is also that 48 hours notice be given in advance of these meetings.
There are some limitations on the Open Door Law. The first limitation is that just because a meeting is public does not mean that everyone in attendance has a right to speak or to be heard. Some meetings allow the right to speak, others do not, and that's something that does not originate with the Open Door Law. That's usually a preference on the side of whatever political subdivision is having the meeting. The second limitation to the Open Door Law is that there might not necessarily be a recording or a video of the meeting itself. Usually the meetings are recorded, and if there is a recording, there would be a right to listen to the recording, but it's not required. The third limitation is that there is no right to attend an employee-related meeting.
One exception to the Open Door Law involves executive sessions. Executive sessions are meetings that are expressly held outside of public view. The two keys for an executive session are, first, this type of meeting can be held only for specific reasons allowed by law, and this reason has to be included in the notice for the meeting. Second, no official action can be taken. This means no final vote. Or no vote of any kind. So if a public body is wanting to meet for one of these specific reasons, like discussing a lawsuit or interviewing an employee candidate or for a job evaluation, that meeting does not have to be open to the public, but it does have to appear in the notice that the executive session is occurring for that purpose.
The second major law allowing public access to state and local governments is the Access to Public Records Act. You may have heard of the Freedom of Information Act, and that is a federal version of the state law. The Access to Public Records Act requires generally that government documents, both state and local, be made available to the public upon request. The specific rules of that are that whatever agency is receiving the request is required to respond within 24 hours for non-written inquiries and within 7 days for written inquiries. It's important to note that the response is not necessarily the actual document or the record being provided to whoever has asked for it. It's simply a response.
Just like with the Open Door Law, the Access to Public Records Act also has some exceptions. Those exceptions include sensitive information like Social Security numbers. Without this exception, I could provide my Social Security number to a police officer because I'm a victim of identity theft, only to have that identity thief do a public records request and receive my Social Security number. Law enforcement investigations that are still underway, those ongoing investigations are not public record. Imagine if a criminal could get information the moment the officer wrote it down. An officer writes down the names and addresses of witnesses, and the criminal who's under suspicion requests all the officer's notes and begins to intimidate those witnesses or to hide evidence. So that just wouldn't work. That's excluded as well. Privileged information, is usually excluded as well. Privileged information is essentially information that does not have to be turned over during the discovery process of a court case. The attorney-client privilege, the doctor-patient privilege are examples of these.
The third area where public records could be requested is within the court system. The Open Door Law and the Public Records Act really don't apply because with the court records we are focusing more on the judicial branch. They generally will set their own rules regarding access to records, and they determine which records on their own are and are not public.
As court records go, it's generally the category that a file is put into that determines whether or not it's part of the public record. As a general rule, court records are open unless a court rule or a judge says otherwise. Court rules are determined mostly by the state Supreme Court. Local court rules can have some input, but for the most part, these don't impact privacy concerns. Court rules typically apply to all cases or categories of cases. Court orders usually only apply to individual cases when it comes to sealing part of the record to exclude it from public view. And that usually only happens after the case has begun and would only affect the records of those parties in that particular case.
I'm going to talk about some of the records that are public within the court system. Those are general civil type actions like a collection action, a personal injury action, or a mortgage foreclosure action. Any paternity case that is filed after July 1st of 2014 is public. That is a change. Traditionally, paternity cases were not public. Divorces are also public, although there are some exceptions to that. Any Social Security numbers that are provided within the course of a divorce are excluded from public access, and also some medical records and things that might come up during the course of a divorce action are also excluded from public access. Guardianships, small claims matters, estate cases, and all criminal cases are public, and the same goes for protective orders.
On the other side at the courthouse are files that are not public record. Most juvenile cases, juvenile delinquency cases, juvenile miscellaneous cases are not public record. Also, juvenile paternity cases before July 1, 2014 are still not for public record and will remain so. Adoptions, mental health records, for example, when a judge orders someone to stay in a safe facility, those are not public record. Children in need of services, also known as CHINS cases, those also are not part of the public record. Those often deal with children in foster homes or state facilities. There are certain parts of a record that is otherwise public that a judge can make not public when he excludes part of the record. That would be, for example, a pre-sentence investigation in a criminal case. That's an investigation that a judge receives before sentencing and contains a lot of details about the defendant. Even though the criminal case itself is public record, that part of the record can remain under seal and excluded. Identifying information about a victim. While a victim's name may be part of a public record in a criminal case or in a protective order case, that identity is generally excluded from public record in terms of the address. If you have other questions about public records in Indiana, you can visit our website or give us a phone call. Thank you.